Hello, and welcome to this webinar by the Export Council of Australia on the European Union's General Data Protection Regulation, or GDPR. My name's Heath Baker, and I'm the Head of Policy at the ECA. The ECA is Australia's only industry association focused on the needs of Australian companies engaged in international business. We have a long, proud history of providing training and skills to help Australian businesses take on the world, as well as providing research into international markets and celebrating success through the Export Awards in New South Wales, Queensland and Western Australia. We also advocate to the Australian Government on behalf of our members, which is where I come in. My focus is to make it simpler and cheaper for Australian companies to do business internationally. I've been hearing a lot from our members recently about GDPR, the European Data Protection Laws, which came into force on the 25th of May this year. I must admit, it's now only recently that I've started to fully come to terms with the burden it puts on Australian businesses and how challenging it can be to fully comply with the regulations. This is something that I've started to talk to Australian trade negotiators about, and something that we're pushing to be on the table for the Australia-EU FTA to reduce the barriers that it presents. So while we're pushing for some longer term policy changes to ease the burden of GDPR, in the short term, we're worried that not enough businesses know that GDPR might be applicable to them or how to comply with it. So we're very fortunate to have with us Cheng Lim, partner with King & Wood Mallesons. Hi, Cheng.
Hi, Heath.
Thanks for joining us. Cheng specialises in helping clients navigate complex legal, commercial and regulatory landscapes in telecommunications, technology and infrastructure. Cheng has extensive experience in privacy, data breaches and data security, having advised Telstra and other clients on these matters for more than a decade. He is the global leader of the KWM Cybersecurity Initiative. Cheng has been working closely with numerous Australian businesses to help them comply with GDPR. Cheng's put together a presentation for us on 12 things that you need to know about GDPR. Cheng, if you don't mind, I might ask some questions as we go, and then we'll open it up to questions at the end by those who are listening live. And for those of you who are listening, make sure to put in any questions that you think of as we go via the GoTo app. Over to you, Cheng.
Perfect. Thanks very much, Heath, and thanks for the introduction. I think one thing I should say up front is that I'm not sort of a European lawyer, but I do come at this from having long experience helping Australian companies with privacy and talking to European lawyers and helping our Australian clients comply with GDPR. And so these are my perspectives on the 12 things you need to know with that lens. So on the next slide, the first thing you need to know is that you have to comply with the GDPR if you are a controller or a processor that has an establishment in the EU. So what does this actually mean? And throughout this talk, I will draw parallels with the Australian Privacy Act. And our Privacy Act doesn't have this concept of controller versus processor, but it has been in the EU privacy legislation for quite a long time. So controller basically means the person who, either alone or jointly with other people, determines the purposes and means of processing of data. While a processor is the person who actually does the processing. So the way I often think about this is if you are engaged in an outsourcing of a function, like an IT function, then, you know, if I outsource the processing of my credit card to someone, I'm the controller because I determine how the information I collect for credit cards is used. The person who does the outsourcing is my processor because he does what I say. So that's a simple way to think about processor and controller. But if you are a controller or a processor of data that has an establishment in the EU, then you have to comply with the GDPR. Now, what does it mean to have an establishment in the EU? Well, the definition of establishment is actually very broad. It is any real and effective activity, even a minimal one. So if you have a website in the EU, with an EU domain, for example, or you have an agent in the EU who you have appointed to legally represent you, that is enough. And even if the actual business processing occurs outside the EU, it might be that your cloud is in the US or in Asia somewhere. It doesn't matter. you are caught because you have that EU establishment.
Okay, so when we're talking about data controllers and data processors, for the sake of a small business, that would generally be if you are keeping the names and addresses and contact details on your website, then you are effectively a processor and a controller. Would that be right? Or maybe you've got the back end through the cloud. So I guess for a small business, does the difference really matter, or just the fact that you are capturing that data means you're applicable?
I think you're absolutely right, Heath, that for a small business, you are probably both a controller and a processor. It does simplify things somewhat, because if you are a controller and you have appointed a processor, then there are requirements about what has to be in your contract. So if you're the same person, it doesn't really matter.
Okay, and if you do just upload your data to the cloud, does Amazon Web Services become the processor, or are you still the processor because you still have control over you can move around that data and where it sits?
You are absolutely still the controller. They might well be the processor, because they are storing your cloud in your data in their cloud, and they will have standard provisions around how they deal with EU GDPR as a processor. Okay, so that's probably a positive then. If you're working with someone, a standard cloud service, you probably, or that they will probably have a GDPR compliance policy. So you'll be able to know where you stand from there. Absolutely. Okay. Moving on to the next thing you need to know, that even if you don't have, so can you go to slide 2? Yep. Even if you don't have an establishment in the EU, you still can be caught by the GDPR if you are a controller or processor, those terms again, that offers goods or services directed to EU subjects, or you monitor the behavior of EU subjects where that behavior takes place in the EU. So let's unpack that a bit, because this can be a bit tricky to understand. So Australian businesses who are not in the EU could still be subject to GDPR if they direct their goods or services to EU residents, or EU subjects as they're called. So how does that, what are the indicia, or what are the kind of things you need to look at about whether you direct things to EU subjects? Well, if you accept payment in euros, that's an indicator that it is directed to an EU subject. If you run a tourist activity here and you buy advertising on an EU website in EU, Amazon.co.uk, then you are directing services, or you're offering services in the EU. And note that you don't actually even have to accept payment. Payment's actually not required. Just the provision of services. If you use kind of EU referrals to market your products, so you might have testimonials from EU residents, if you like, that can be enough to say that you're offering goods or services to EU subjects. The other leg of this is monitoring the behavior of individuals in the EU, where that behavior takes place in the EU. This is a bit trickier, because this looks at profiling, for example. So if you try to profile people who are resident in the EU in respect of their behavior in the EU, I've seen commentary which says that this could include cookies, which it's quite tricky where your cookies are specific to individuals and you tag where they come from. I was trying to think of a practical example of this. It might be that if you offer an IoT type service which does home security, and people in the EU might have a camera connected to your security system, that could be caught. But the second leg is is quite a bit broader and can be quite technological in terms of trying to work out whether or not you are within the GDPR.
Okay, so in terms of monitoring EU subjects, I guess that's a very sort of relatively niche area for Australian businesses. And if you are doing that, then you are probably pretty well aware that you are captured by GDPR. However, if you are selling goods offering goods or services directed at EU subjects from Australia, when you are based in Australia, this is the area where I think the real concern is that Australian businesses just don't realise that they're being captured. So we have here, if you accept payment in euros, if you advertise in Europe, so if you're sort of proactively taking steps to target Europeans. What about if you had, say, in different languages on your website, like German or French, for example, that aren't really spoken outside of Europe? Would that be enough to capture you?
That is another indicia. That is, if you have options for EU language translation, absolutely. Also, if you use a top-level domain, so if your website has a .eu or .de or .co.uk domain as well.
Mm-hmm. Okay. And then when we say EU subjects, does that capture just EU residents, or what about EU citizens outside of the European Union?
No, it only covers people in respect of their behaviour in the EU. So if you're tracking a German who's in Australia because they come to Australia and they buy goods and services here, that's not caught.
Okay, so it matters when the actual transaction or good or service is offered. Are they in the EU or not? If they're not in the EU, if let's say they go from Germany to Australia on holiday, have the holiday in Australia, end up on an Australian database because of something they did during that holiday, and then fly back to the EU, you're not captured by GDPR.
Yeah, but you do need to be a bit careful, right? Because if you have your website, and let's just use the German tourist, for example, and you have you accept payment in euros, or you have a German language translation on your website, but you don't actually sell them anything while they are in Germany, but when they do arrive in Australia, you do sell them something. You still could be caught because you're offering goods or services in the EU.
Right, so you're marketing in the EU, or
Correct.
at least making it easy for the European consumer to engage with you, even when that point of sale is in Australia.
Correct.
Okay, so it is very broad. Okay.
Yep, okay. Well, I might move on to the next principle or thing you should know, which is the fact that the GDPR and the Australian Privacy Act actually have a lot in common. But although they have a lot in common, you actually have to ensure that you approach compliance with each of them separately, and you think about it separately. Now, the OAIC, the Office of the Australian Information Commissioner, has actually produced quite a good guide to GDPR compliance for Australian organisations. So if people haven't seen that or are not aware of that, I'd recommend they get onto the OAIC website and download it and read it. There are many similarities between the two. So, there is a general concept of privacy by design, which is explicit in GDPR, and we'll talk about that later on in this talk. It is implicit in the Australian Privacy Act, but generally, you need to be able to just demonstrate that you comply with the privacy principles, and you have to have transparent information handling processes. So those are some of the things which underpin both GDPR and the Privacy Act. The compliance regime, however, is different in the GDPR because it has very strict compliance rules. So if you have to comply with requirements of the GDPR, then you have to be able to demonstrate it. And we'll talk about some of the things that you have to do. For example, the GDPR does require you to appoint a data protection officer in certain circumstances. Breach notification, mandatory data breach is different. Compulsory data protection impact assessments are different. And some of the rights that are given to data subjects are actually different.
Okay.
Sorry, go on.
I was just going to say, so there are a lot of similarities, but there are enough differences that you really need to do your homework.
Correct. So if you're familiar with privacy, then many of the things in GDPR should not surprise you. Where they are surprising is some of the things that I'll talk about, which I've tried to draw out a little bit. So if we can move to the next slide, which is slide 4, you must comply with the GDPR's data protection principles, which is kind of self-evident. Many of these, and here are the similarities, are very similar to the Australian privacy principles. Lawfulness, fairness, and transparency. So, you must treat information, personal data, and the definition of personal data in the EU is very similar to that in the Australian Privacy Act. It is information which, allows an individual to be identifiable. So you must collect information lawfully, you must collect it fairly, you must be transparent. There's a purpose limitation in the GDPR, so data must only be collected for specific, explicit, and legitimate purposes and not used in a manner which is incompatible with them. You must minimize the amount of data that you need, so personal data must be adequate, relevant, and limited to what is necessary. There's an accuracy principle. Data must be kept accurate and up to date, and you must take every reasonable step to correct or erase inaccurate data swiftly. There's a storage limitation. Data should only be kept for so long as necessary for the original purpose. There is an integrity and confidentiality kind of principle, that is, you must take appropriate technical and organizational measures to protect against unauthorized or unlawful processing and accidental loss, destruction, or damage. So, those are all, aligned very much with the Australian privacy principles, and one would hope that the way you treat personal information in Australia is absolutely consistent with the way you would treat GDPR information. So you don't need to make massive changes to a lot of your fundamental privacy compliance principles, which is good.
Absolutely.
But moving on to some of the more interesting rights that EU data subjects have, which is slide 5. This is the right to be forgotten. So EU subjects, data subjects have the right to be forgotten. This is also known as the erasure right. And effectively, it basically says that in certain circumstances, data subjects have the right to be forgotten, that is, to have their data erased. It's not an absolute right across all circumstances. It applies basically where the data is no longer necessary to achieve the purposes for which they're collected. So, I can ask for it to be deleted once, my order is complete. I have a right to erasure where I withdraw my consent. So if I given consent, but I subsequently withdraw it, then I have the right to be forgotten. If I have an objection to the processing of my data, or if I'm a child, and there's certain circumstances in which children, which are people under 16, can give consent, if they want to withdraw that, or where there's some other non-compliance with the GDPR. In those circumstances, then, if one of those apply, then I have the right to require the controller to erase my data, and the controller must take reasonable steps, taking account of technology and the cost of implementation to do so. Now, there are also exceptions. I don't want this whole thing to be about the right to be erasure, but I think it is quite an interesting right because it is quite different and we don't have that in Australian privacy legislation.
So, Chen, can I get you to just draw you out on that a little? So, what is the obligation for companies under the Australian legislation?
So, if you have someone, for example, who has placed an order on your website for a product, and you fulfill that order, you've shipped it to them, and they paid for it, and they subsequently say to you, well, please erase my data from now on. What that means is you have to effectively delete their account, so that you, because the data is no longer required for you to process their order. You may keep a historical record possibly, because you might say, well, I have an interest in, if I'm worried about a legal claim, like I have a warranty claim, or I have a warranty exposure on that, so I might have 12 months where I would need to make sure that I keep a record that someone has bought it from me. But just because I've got a backup situation, I might still have to take reasonable steps to delete it from backups, as long as as that's technically feasible. So it's quite a complex right, and I think this is one of the ones which people in the EU do struggle with the technical implementation of this. In the past, it's been the Google right to be forgotten. When someone says, delete me from searches in Google and take me out of the cache because my convictions expired, or that article about me was defamatory, and they've asked for it to be removed. That's some of the origin of this right to be forgotten.
Okay, so I guess that would lead to a lot of practical challenges as well as technical challenges, in those instances of warranty as well. So it's probably too early to tell the implications for that exact example that you gave in terms of when you've got a warranty claim where someone's been purged from your database, so you've got no record that they've purchased from you, they've asked to be forgotten, but they then come back with a warranty claim, so you need to re-establish that transaction took place, and that would put the onus on the consumer, I would assume.
Yeah, it probably does, especially if they're the ones who told you to kind of erase their account.
Mm-hmm.
Yeah, they may have to send you a copy of the invoice, for example. But I don't. I think this is a particularly technical one. So if someone issues a erasure notice, you don't have to action it unless they fall within one of the categories under which you're entitled to exercise that right, and you don't need to delete them or erase them unless, if one of the exceptions applies. So it is kind of, you've got to work through it quite carefully.
Yeah, but presumably you would still need to have the ability to do that at any time. Is there a time limit given for when it's acceptable to, how long it's acceptable to take to erase someone?
You have to do it within a month at the latest. You have to do it without undue delay.
Okay, so that month time frame is really too short a time to be able to put in place a solution for a one-off instance.
Yeah, I think you'll have to look at some of those case by case.
Okay,
and
great.
do a manual process if you have to. All right. Why don't we keep moving at the halfway mark? The next right I thought was interesting to talk about is data portability. So the GDPR gives EU data subjects the right to data portability. And we don't have an equivalent concept in our Australian Privacy Act, but we do have something which starts to come close to data portability in our proposed consumer data right. And Heath, I don't know if you're going to do a session on the proposed consumer data right, which has come out of open banking, but there's a lot of consultation happening on legislation and the ACCC's framework on the consumer data right. Effectively, this this data portability concept allows individuals to obtain and reuse their personal information for their own purposes across different services. So effectively, it's not just to get, for someone to say to an organization, give me the information you hold about me, because we actually do have that concept of getting access to information under your own information under the Australian Privacy Act. Data portability is about giving my information to another provider. So if I use a bank as an example, data portability would say, I can say to my bank, I've opened an account with Westpac, hand over the information to Westpac. You can see the same thing with the telecommunications organization. So it's intended to make competition easier by allowing customers, individuals, to have their information easily transferred to another service provider. There's kind of two things where this applies. One is it's got to be based on where the information's been obtained, where there's specific consent or for the performance of a contract. So that goes to kind of this whole thing about competition. And the "and" is important, is where the processing has been carried out by automated means. So effectively where there's structured data in a database. So, if you only ever keep paper files, heaven forbid, then actually the data portability doesn't require you to transfer that information.
Okay, so if you're dealing with a European client just on a one-on-one basis, and you fulfill a contract, you probably won't be captured by that because it will be more of a sort of a one-on-one. Whereas if you are offering sort of a high volume service in terms of a high volume of consumers, and it's just a straight through automated process, you will get captured by that.
Yeah, probably one-on-one's not the right. It's a once-off as distinct from a continuing series of transactions. So it might be that it's you're providing a monthly service of some sort out of Australia, and they go, well, actually, I'd like that service to be provided by someone else.
Yeah. Okay. So where that data and where the record of that data has value, as opposed to being at a street contracts, and would sort of commercial in confidence kind of provisions apply as well? No, it's not. It's not
confidentiality doesn't govern this, and because in a sense it's my information. So it's about and one of the big debates in data portability is how much information about me is portable, and it's the same debate which is happening in Australia, which is clearly information that I as an individual give to an organization, and information about my transactions. So if I take banking as another simple example, so my transactions on my account are information about me and is portable. But if the bank's done a credit assessment of me based on a whole lot of value-added data they've used, then that may not be portable. So there's a line there.
Okay, great.
Moving to the next principle, the next slide. I talked about DPIA's data protection impact assessments. So the GDPR does require you to conduct these data protection impact assessments in certain circumstances. So in Australia, we do privacy impact assessments. Typically, it is done in the public sector in Australia. So a lot of government organisations will do a privacy impact assessment, and that looks at a particular product or a particular initiative and runs through effectively the life cycle of that and tries to make sure or understand what the privacy risks are and to minimize them. So it is a little bit of privacy by design. Same concept here in the EU, that you have to do a data protection impact assessment. And that's in order to mitigate the risks for privacy in data processing. So when do you have to do it? You have to do it if you undertake high-risk processing activities. So if you're processing sensitive information, health information, criminal convictions, things like that in high volume. If you're doing systematic profiling of individuals, which leads to automated decision-making, for example, some sort of credit checking type service. If you're doing large-scale systematic monitoring in public areas, you know, if you run a CCTV network, for example. And once you kind of fall within that, then you have to do a DPIA. And I won't go through DPIAs, but you know, they are reasonably well-structured processes, and there are lots of people who kind of do DPIAs as consultants to kind of actually go through the entire thing. Sometimes you have to consult with the regulatory authority, particularly if you're doing these high-risk activities. You know, that might impact the timeline of your project, so that's just something to factor into account. And you know, it might be that you might have to consult data subjects as well. So again, yeah, the point about DPIAs is the kind of the regulatory process and the time frames required. And obviously, if something comes out of the DPIA which says that, well, you shouldn't do it this way, you should do it that way in order to protect privacy, then you will have to comply with that.
Okay, so that's the really more sort of more sophisticated end of the spectrum, where if you're engaging with those kind of sophisticated analysis, you'll probably know, you'll probably be quite aware of GDPR and your obligations under that anyway, one would hope.
Yeah, one would hope.
Excellent.
The next thing you need to know is about data protection officers. So you may be required to appoint a data protection officer under GDPR. So if you're caught by GDPR, that is, you have an establishment in the EU or you provide goods and services in the EU, you have to appoint an EU representative. So that's a person who can receive notices from regulatory authorities, who can receive information from customers or complaints, etc. However, if you do certain types of things, or you're a certain type of organization, in addition to having a representative, you must appoint a data protection officer. These organizations who have to appoint DPOs are public authorities and public bodies, organizations which carry out systematic and regular monitoring on a large scale. If your core activity involves large-scale processing of sensitive personal data, or if under a law of an EU state, you have to appoint a DPO, then you have to appoint a DPO. So an example of where you would have to appoint a DPO is, and if you are, for the sake of argument, an Australian HR company which provides payroll, provides recruitment services, and you have an operation in the EU, so you're collecting information about employees. There might be health, not just name and address, but obviously that would include health data, employment data, all of that sort of stuff. So that would include large-scale processing of sensitive personal data. And because it is a core activity of yours, because your business is HR processing, then you would have to appoint a DPO. Now, HR is not typically core activities for normal businesses. So if you're just a company and you have a HR function, that's not considered a core activity. So you wouldn't appoint a DPO simply because you have operations in the EU or you have some employees in the EU. So if you have to appoint a DPO, that person has rights and obligations under the GDPR. So you must have a certain level of qualification, you must be expert in European data protection law, you must report to the highest level of management. The organization has to provide DPOs with adequate resources. So it's quite a significant role. It's intended to be someone who represents the voice of the individual in management. So if the marketing function in an organization says, oh, I want to collect this information and use it for these purposes, the DPO's role is to kind of make sure that the interests of the customer are protected from a privacy perspective.
And what's the, I guess, enforcement around that? Because I mean, you can appoint a DPO in name, but without having that sort of strong voice in the company. How do they ensure that the DPO does have that strong voice in the company?
Well, it places these requirements to say that you must do these things, and a failure to do these things around the DPO could result in a breach of the GDPR. And I can talk a little bit more about consequences and penalties a bit further on. So, you know, if you're
so basically it's
serious consequences.
Yeah. So if there is a breach, they will then sort of go back and say, okay, show me evidence of your DPO being that consumer advocate or individual rights advocate. So the onus is on you to prove that they played that role.
Correct. So let's say there's a privacy breach, and they go, well, what did your DPOs? This should have had an impact. It says a DPIA. It's a DPO's role to make sure that a DPIA is carried out. Was it, why didn't they do that? Or if a DPIA was carried out, did they express concern about the outcome? And the Article 29 Working Party, which is a working party of one of the EU organisations, which has put out a lot of guidance, kind of says, if the DPO objects, they should make sure that their objection is documented properly. So there's a lot in compliance, which is around documentation.
Mm-hmm. Okay. But again, if you are just a small business selling, I don't know, let's say hats to the EU, because you fall underneath that threshold, you don't need to put in place a DPO.
Correct. But
unless you're doing extremely sophisticated marketing around that.
Yeah, but there can be a small business which deals with processing of sensitive personal information. For example, you might be just a specialist in health claims under superannuation, for example. You might be doing medical transcription for a hospital. So you've got to be really careful about saying just large organisation versus small organisation. It's really about the type of information you hold.
Okay. All right. Excellent point.
Okay. The next one is about mandatory data breach, and obviously in Australia we have mandatory data breach notification legislation sitting in the Privacy Act. In the EU, the GDPR also has a data breach notification requirement. The key difference, I think, is that GDPR has a very strict time frame. So you have to notify the regulatory authorities there within 72 hours if the breaches are likely to result in a risk to individuals' rights and freedoms. And the phrase result in a risk to individuals' rights and freedoms is quite a broad phrase, and you have to think a little bit about what that means, but that could cover a leak. So if someone has accessed your customer relationship management system or your kind of customer database and have got their personal details, but it could also cover where you've been hit by ransomware and your systems have been encrypted, so you can't provide services. So that is also considered to be a risk to their rights or to transact with you. So it's not just that information has necessarily leaked that this principle applies. And the 72-hour time frame is quite short. It's 3 days effectively. The Australian regime requires you to kind of come to a view that there's a likely serious harm to result from a breach before you have to notify. And in Australia, if you're not sure whether or not there's serious harm, or you're not sure what has been taken in the breach, you have a 30-day period to investigate and use reasonable efforts to expeditiously investigate and come to a view. But in the EU, you have to notify the ICO or the relevant sort of a regulatory authority within this 72-hour period. So I'll give you a good example of how that plays out. And this is public knowledge. So in the PageUp incident, which happened earlier this year, PageUp had an operation in the EU. They had employees in the EU. And because of this requirement, they took the view that and they have their own, they PageUp, for those of you who don't know PageUp, they're a recruitment organization. They took the view that they had to notify in the EU in respect of the incident within 72 hours. And because they had to notify in the EU, they decided to make a public statement in Australia at the same time, because they thought it would be very bad for them if they just notified in the EU and didn't say anything in Australia. So they gave a notice in Australia. It was not a notice under the Australian legislation at that point in time, because they didn't know the potential scale of the impact. But it just goes to show, if you like, that when you're doing business in multi-jurisdictional things, that sometimes you have to make sure there are consequences in your home jurisdiction as a result of regulatory requirements overseas.
That's a really good point. And just to be clear, so the last couple of points we've been talking about your requirements if you are quite a sophisticated data processor or data controller or involved in niche areas. This requirement to notify authorities within 72 hours applies to everyone, doesn't it? So if you're captured by GDPR, then you must be able to respond within 72 hours, regardless if you're just doing the most vanilla thing in the world, the small business exporting hats, for example, you must be able to do that.
Yes, correct. And there's two levels of notification, similar to Australia. So the 72-hour requirement is to notify the regulatory authorities. And if there's a risk to high risk to individuals' kind of rights and freedoms, then you also have to tell the individuals as soon as reasonably feasible.
So one of the things that's set off alarm bells for me with GDPR, and I'm not sure if you're going to mention it in one of the subsequent slides, but it is the way that you do that notification and who you notify it to. So my understanding is that you are required to notify one of the EU's one of the national regulators. But in order to do that, you need to know in advance which regulator you're going to notify it to. But you also need to have some sort of formal presence or some sort of formal reason why you are able to report to that jurisdiction's regulator. Is that correct?
Yeah. So you have to appoint a representative in the EU, as I said, and typically you will appoint someone in the country in which you have the most closest connection, if you like. So once and that happens in your setup phase, because you appoint the representative and therefore you know who your local supervisory authority is. So if you have a data breach, that's typically who you would go to first. In the case of a DPO, if you have a DPO as well, you only need to notify the lead supervisory authority in your jurisdiction. It's less clear with the representatives. I think the practical answer is that you contact. Let's say you have you operate in Europe and you have your main office is in London, for the sake of argument, but you might have offices in Paris, or you might have some customers in Paris and in Frankfurt. If you have a breach which affects all of them, you will notify the ICO, the supervisory authority in London, and then you would talk to them about whether you also need to notify the German and the French supervisory authority, or whether the London supervisor will coordinate with his counterparts.
Okay, so if you don't have an office in the EU, how do you get a representative? What is there a sort of a standard process? Are there people that offer, say, representative services?
Yeah, they are. I haven't. Most of the people we deal with, either have representatives themselves or have offices. But I think from memory, my understanding is that there are people who will do these things for a fee.
Okay, So in that case, you can kind of almost jurisdiction shop to find out what's the, I guess, what's the easiest way for you to, what's the easiest jurisdiction in which to put your report. And for most Australian companies, that would be an English-speaking jurisdiction, so Ireland or the UK.
Yeah, that would probably be sensible. Although, if you basically primarily only have German customers, then I think, you probably need to have, you need to look at where the customers really are.
Yep. Okay. That's a really good point.
Cool. Moving along, the next slide is about compliance effectively, and it just reinforces what I said earlier. That is, you should be implementing organizational technical mechanisms to protect data. So the GDPR has a lot of requirements, and compliance is a really important part of it. And one of the GDPR does require you to use technical and organizational measures to show that your compliance activities have been properly integrated into your organization and the processing activities that you undertake. So, and if you comply with Australian privacy principles, by and large, you should kind of, comply with many of these things, apart from some of the special things that I talked about, around data portability or the right to be forgotten, because we wouldn't have some of those things in Australia, but things like transparency, things like, making sure your privacy policy is up to date, things like, making sure that information is current. All of those sorts of processes should be built in. But obviously, kind of, you need to make sure that you have processes to comply with things which are in GDPR, which are not, in your current processes for Australia, and you may need to document all of that sort of stuff so that you can demonstrate that compliance.
Okay. Excellent.
Then moving along to the next slide, what happens if you breach GDPR? Well, there are very significant sanctions, and this is the big stick that the Europeans have wielded in order to kind of get people to actually sit up and listen. There are two tiers of fines. The higher tier is up to 4% of annual worldwide turnover, or 20 million euros, whichever is greater. The lower tier is 2% of annual worldwide turnover, or 10 million euros, whichever is greater. So the higher level of fines apply if they're breach of the key kind of principles, lawfulness, transparency, fairness, etc., or breach of your data subjects' rights. Things like transfer outside the EU, if you don't implement the right to be forgotten, those sorts of things. The lower tier typically applies for some of the other compliance things. If you can't demonstrate some of your compliance, then that would be subject to the lower fines. Note that these are caps. They're not obviously the fines that would necessarily be applied. So authorities will typically consider mitigating measures, your level of cooperation, have you tried, or whether you've just decided to flout GDPR.
So those are very, very big sticks the European Union is wielding. We're only a few months into the regime being in force. Has there been much by way of enforcement, either within or outside the EU, that you're aware of?
There have been some high-profile sort of privacy issues in recent times. I think in the last month, we've seen a potential Facebook breach, for example. I'm not aware that a fine has necessarily been levied yet, but one would expect that the EU would be looking closely at those sorts of events. But I'm not aware of a big fine on GDPR since it's just been implemented. There've been other kind of European fines on Google for anti-monopoly that I'm aware of, but not for GDPR.
Okay, and it's the ITOs, so the supervisory bodies in each jurisdiction that will do the monitoring and enforcement of that.
Correct. Correct.
Okay.
So the last thing to leave you with on this talk is kind of just to say, well, what are the kind of three most important things you should be doing if you don't know anything about GDPR? I think, firstly, yeah, understand and work out if the GDPR does apply to you or if it doesn't. And if you're not sure, get advice, and there's lots of people who will kind of help you if you're not sure. But if it does apply, then you need to kind of have a compliance program to make sure you understand your obligations and you can actually comply with them, implementing the right to be forgotten, implementing data portability if necessary. And finally, the third thing is you need to keep records of what you're doing. So it's not enough to say you're compliant. You actually have to be able to demonstrate that. So the paperwork's actually really important. And that's what a lot of people are doing, getting their house in order.
Okay, so it's not just about the IT systems, it's about the the record keeping as well, that you need to be aware of exactly what you need to do, exactly what you need to be able to prove, and keep a good record of that.
Yeah.
All right. So we've got a little bit of time for questions. I've got a couple of questions here from the audience, and we've got quite a few people online. So please send in questions if you have any. Well, we can hopefully get to a few of them. So the first one is from Kiara, and it is just asking for clarification. If you are keeping the information on your subscribers to your website, you are both the controller and the processor, are you?
Yes, so that's sitting entirely in your environment. Yeah.
Okay. All right, that's pretty straightforward. Second one is from Christina. Is there a list of the ITOs, the supervisory authorities, for each jurisdiction? Is that pretty easy to come across?
I'm not sure if there's a consolidated list, but if you Google the supervisory authority for whichever countries you're interested in, that will be come up pretty quickly.
Yeah, I've got to admit, I've found a lot of my information on GDPR from the British regulator. I can't tell you off the top of my head what they're called, but they are pretty easy to find on the website, and they have some really good information.
Yeah.
And speaking of,
so it's ico.org.uk for those on, and they have a very good guide to the GDPR.
Okay, and speaking of the UK, I've got a question from Tony. I'm exporting to the UK. Do I need to worry about GDPR given Brexit in March 2019? I guess that's a huge question.
Well, at the moment, obviously they haven't exited, so you do need to worry about GDPR. I'm not as close to how Brexit is going to happen, but as I had understood it, the way that it was going to work was that they would comply with European laws which were enforced at the time of Brexit. And if that is the case, then GDPR is part of the European law today, so it would apply, at the time Brexit occurs.
Okay, right. So I think yeah, the principle I would say that is if you are doing business with the UK now or in future, it's probably just best to why limit your data your product or service offering to just the UK, and just design it in if you can.
Agreed.
All right. Well, thank you very much, Cheng, for that very informative and insightful presentation. You can contact Cheng at Kingwood Mallison for any follow-up discussion. His email address is cheng.lim@au.kwm.com. And as Cheng mentioned, the Office of the Australian Information Commissioner website has some good information outlining the similarities and differences between the Australian and EU privacy requirements, and also Cheng just mentioned ito.gov.uk as well for some really good information on it. Just a reminder that the ICO, sorry, ICO, I stand corrected. So I just want to remind you that the Export Council is a membership-based organisation, and we work hard to advocate for the needs of our members. One of the things, particularly for GDPR, that we are advocating on is the requirement to work through a through a registered entity that is within the European Union. There are certain jurisdictions that have special relationships, and their privacy regimes are recognised by the EU's, and Australia's isn't. So we're going to be working actively to try and resolve some of these more some of these areas that make the GDPR more difficult for Australian firms to comply with. So we're going to be advocating on behalf of Australian businesses to hopefully reduce the compliance burden of GDPR. And if you want to support us in doing that, you can join us by visiting export.org.au/membership or calling 02 8243 7400. All right, thank you very much for your time today, and please, if you've got any additional questions, send us an email at info@export.org.au. Thanks very much, Cheng.
Thanks, Heath.
And thanks everyone for listening.